on land reform, and we're going to unpack various ways to achieve it. Advocate Tembeka Ngcukaitobi believes land reform in South Africa has collapsed. He adds that the country cannot achieve an equitable land redistribution and restitution program through a titling system in which a few people are given title deeds. He joins us now to unpack this further. Advocate Ngcukaitobi, good evening, and thank you for your time tonight here on In Focus.
Thank you, Tabo. Thank you for the invitation.
How is government facilitating entry into land ownership in the country? I mean, is land reform regressing, on its way to regressing, or has it completely collapsed?
No, the picture is always a mixed bag, but overall the prognosis is a negative one. Land reform, if you measure it by its three constitutional pillars, restitution, redistribution, and land tenure, is actually going backwards. And one of the reasons why it's going backwards is the lack of adequate capacity and lack of support. The minister also accepted in Parliament recently that her own department simply does not have qualified people. The budgets for land reform have increasingly been reduced. The past 12 years have simply not been positive for progressive realization of the entitlements that are in the Constitution for sustainable land reform. The institutions themselves have been, the word is hollowed out, but the institutions have been losing key quality personnel, and those have not been replaced. And the commission is not functioning according to its capacity. The department is not functioning according to its capacity. So, and then there is also just massive policy confusion, and there is no clear direction about where the country wishes to go. The current discussions in Parliament are also not promising. At some point, there was a debate on expropriation without compensation. That seems now to have morphed into a conversation about issues like custodianship, which have not been fully ventilated in the public discourse and deliberation. So if you look on the institutional front, you look on the policy front, you look on the budgetary front, the signs are rather bleak.
Restitution is still at 2 billion as far as budget is concerned, according to the latest submissions to Parliament. And restitution, that is where people who can show that they were dispossessed previously are able to claim. Any new proposals on that front to speed up that process?
Yes, I mean, nothing really driven from the center, in other words, driven from the state, has actually come up. What we need, so you're right in relation to explaining what restitution means, what that program was intended for. This is a program introduced in 1995 as part and parcel of the Restitution Act. What it intends is that if you can show that either yourself or your predecessors, your grandparents or your parents or your great-grandparents, were dispossessed of land or a right in land. So could either be a piece of land or an entitlement to occupy that piece of land derived from a variety of legal sources. If you can show that that was taken away from you or your predecessors from the 19th of June, 1913, you would be entitled to claim that back. That was primarily intended to help the victims of the 1913 Native Land Act and the subsequent pieces of legislation, 1936, the Group Areas Act, and all these other statutes. So that was intended to help essentially victims of forced removals to reclaim the rights that they lost under forced removals. It has inherent limitations. One of its limitations is the cutoff date, is that 1913 itself is a limiting factor. So anything that happened before 1913, you wouldn't be able to claim it back. But it also has institutions that are designed to facilitate that process. The main institution is the Commission for the Restitution of Land Rights, and that commission hasn't got sufficient capacity. The problem today that faces that program is that a lot of claims that were submitted before the first cutoff date in 1998, there are many claims. I think the number is something like 7,000, but there are many, many claims that have not been resolved. They are piling up, and there is no strategy towards the resolution of those claims and settling them. And the other problem is that the government in 2015 reopened the land claims process, and that reopened process resulted in something like 75,000 new claims, And so those new claims were stopped by the Constitutional Court order, which found that the amendment which enabled the new claims was unconstitutional. Those claims, the majority of them are competing claims. In other words, they're claims of people that are competing with already existing claims. So, in your own community, someone else will come and say, actually, it's not Thabo Mdluli's land, it's actually Tembeka Ngcukaitobi's land. And so I'm competing with your own claim. So a lot of those claims also have simply not been processed. So that's one of the major problems. The other problem is what is called post-settlement. So when you have received the land, how do you continue the productive agricultural activity? Have you got the capacity to do it, and how do you sustain it? And there is no support there. Yeah. The result is that I think the numbers the last time I checked was something like 89% of all farms, commercial farms that were transferred under this program have simply not continued the productive agricultural activity. So that too has not been a positive thing. And then there is another problem, which is the way in which government compensates land claimants. When I asked for the figures, I think in 2018, the figures I got then was that since 1994, the government had paid something like 60 billion as part and parcel of land reform as a whole. And when I asked where most of that money had gone, most of that money had gone to white landowners. Yeah. And very little actually had gone to claimants. So what that meant was that the program of restitution has actually benefited the white land-owning class. Yeah. And it has not actually benefited black land claimants. So those three features of it, they convinced me that the program is not like it's stagnated, but it's actually going backwards.
Let's hold it there for now and take a break. When we come back, we continue to look at the lopsided nature of the restitution process and what's the hold up. Instead of focusing on the compensation provision, why did we not opt to focus on the shifting of the date of 1913? Is land reform regressing, in the process of regressing? Or, of course, is the government's approach, new approach, seemingly facing and focusing the tenure rights, fundamentally also the conversation around the custodianship of land? Is that debate properly placed? We'll talk to those issues in a moment. I have with me Advocate Tembeka Ngcukaitobi, and we're, of course, getting into some of those questions tonight. So before the break, you were talking about particularly this question of the cut-off date. Now, 5 years ago, President of the country then was President Jacob Zuma, addressing the House of Traditional Leaders. He says, I believe as a son of a black man, being black, that we need to shift the cut-off date, but you need to find a reasonable way of addressing the issue within the Constitution. Yet the party opts to change the compensation provision and have not tackled that. Why?
Yeah, that's one of the difficulties that are embedded in this process of the amendment to Section 25, subsection 2, sub B of the Constitution. The big problem, of course, is that, most of the problems with land reform have very little to do with the compensation provisions. The problems of land reform are restitution and redistribution. But I think that a discussion about compensation immediately shifts the focus to landowners and therefore takes it away from where really the conversation ought to be, which is the sort of institutional disarray that is driving the process. So yes, once this amendment has been finalized, we will still remain with the 1913 cutoff date, and we will have done nothing about the redistribution leg of land reform, and we would have done nothing about the tenure leg of land reform. So all of the problems that are bedeviling the land reform program right now will continue to remain after the amendment, because the amendment, of course, focuses on a totally wrong target. But it also raises another problem. You know, President Ramaphosa once mentioned, I think it was in 2018, if I'm not mistaken, that what his government wants to do is to solve South Africa's policy problems by reference to evidence. I think he referred to it as an evidence-based policy-making approach. But the Section 25 process shows precisely what is wrong. There is no evidence whatsoever that the compensation part of the Constitution has been an hindrance or a stumbling block to land reform. Zero. The Motlanthe panel report was quite clear that the compensation part is not a problem. A judgment by the Constitutional Court called Mwelase was quite clear that it pointed about 8 problems, but they fall outside. The presidential panel itself made it clear that the compensation part are actually not the problem. So the energy that is being spent on the compensation provision is not justified by reference to the actual evidence. And so ultimately, once the process is over, we will come back to exactly where we are, which is we would have made very little in relation to the transfer of actual property, of actual land, to the hands of the landless.
Let's look at land redistribution then, equitable access to land for settlement settlement and commercial purposes. They've seen a cut there, I suppose, during these austerity times of 300 million. How does that impact on that program? And we saw the minister also talking about a release of some land parcels that are owned by the state to otherwise qualifying beneficiaries. How did that process go?
Well, I mean, it's not promising that either, Thabo. You know, the fact that there was a significant budget cut is quite a severe thing, because it shows that on the one hand, you have this talk, and I've referred to in another piece I wrote as rhetoric. You have this talk that we are speeding up land reform. We are now finally doing what we should have done for 27 years under the Constitution. But if you actually look at practice, what are they actually doing as opposed to what they are saying? What we find is that they're reducing the budget for land redistribution. We also find that their institutions are in total disarray. So if you look at, I mean, quite apart from the fact that they've cut the budget by 300 million on a year-on-year basis, if you look at another program with land redistribution, which is the lease program. So what you call the land parcels is essentially the lease program. And the way it works is that the government buys land, right? Once it has bought the land, it warehouses or keeps it or places it under its own custodianship. Thereafter, it dishes it out through a lease program. And those leases, I asked the officials to give me copies of those leases. I've got about 3 of them. What they provide for is, I mean, in the one instance, it was something like 300 hectares. So it's big pieces of land. So one person with 300 hectares will pay a rental of something like 60,000 per annum, you know, which is negligible if you consider the size of the land. But there is a problem in the collection of those rentals either. There's no full accounting of how those rentals have been collected. But there's also no transparency as to who gets the farms. I mean, you don't know who gets the farms. It's never actually publicized for everyone to apply. But there's also another problem. I mean, a research, I think it was done by Professor Ruth Hall and Professor Tembeka Ngcukaitobi. The research done, I think in 2016, showed, especially in the Eastern Cape, that there was what they call elite capture. So the farms were going to people that were associated with politicians. They were not going to genuine small-scale commercial farmers. And what we know is at the beginning of this year is there was total confusion about the allocation of those farms.
So what do we know about the 44,000 that the minister reported about applications for this 700,000 hectares, which would constitute about 627 farms? They're saying they've got an electronic management system for this database. Does it give us any information?
No, we know actually very little. I mean, if you actually take a drive yourself, go to a province, whether it's Limpopo, and just ask for which land, just a basic question, which land is available in the province. I took a drive and I went to 3 of the farms down here in the Eastern Cape that are supposedly part and parcel of this farm lease program. The first problem is that some of those farms are actually occupied by people. But the system in the department, there is no reliable database that determines that a farm that already has an occupant should not be put on the farm list program. So on the one hand, you've got these numbers of 44,000. I mean, I've not seen the actual names of the applicants, but let's grant them that people have applied. The problem is you don't have a clean database that says only those farms with no present tenants or no present occupants. And what actually happened in places like the Western Cape and in places like the Eastern Cape is that the same farm was allocated 3, 4, 5 times. And so when people actually took the keys and they went to the land, they discovered that it was already occupied because the systems are in such a state of disarray that it's impossible to work out who is where. And so that's why I don't make the point lightly when I say my fear right now is not that the process is failing, but the process is actually going backwards.
When we continue next with Advocate Tembeka Ngcukaitobi, you'll find out why he thinks Title Deeds Friday is actually a wrong idea. The president a couple of weeks ago repeating, I suppose, that statement that he made in 2018, that title deeds would now be released every Friday, and saying that is an indication of advancing in the land reform program. Stay with us. We'll continue in a moment. How government is facilitating, I beg your pardon, entry into land ownership in the country. The conversation tonight with advocate and author Tembeka Ngcukaitobi. Now, we have touched on two aspects, advocate, the land restitution and the land redistribution. But the final leg or the final pillar of land reform in the country is security of tenure, where we transform the rights of persons over the land. Now, a couple of weeks ago, again, the president released some title deeds, and you remember in 2018 he declared Fridays Title Deeds Fridays. Government seemingly, at least public confession and their actions, prefer land tenure system. Why, and do you think this is the correct route to go?
Yes. Well, I mean, there are 3 problems I've pointed to in relation to the titling system. I mean, the one problem is that the titling mode, which is the consolidation of a private entitlement to a piece of ground, by its very nature is exclusionary. So each title that is given to you or me represents a larger pool or a larger class of people, the disentitled or the unentitled or the untitled. This is a mechanism of excluding. That's what is at the essence of a title deed. It's determining who is, not so much who is inside, but determining who's outside. So that's the one problem. It's exclusionary in its very nature. But there's also another problem with the titling model. If you go to places like Soweto with many people there who live in those areas, or Alex for that matter, with many family members, the problem is always who do you give the title to? Do you give a family title or do you give a title to the head of the family? But who do you actually give a title to? Because titles tend to be, they don't always have to be, but they tend to be individualistic in their nature. And embedded with that problem, associated with that problem actually, is the underlying assumption that title deeds are a mechanism. And I saw it in the speech of the president as well when he gave the 30 farmers title deeds in Groblersdal. The assumption is that a title deed is the silver bullet that would unlock credit from financial institutions. But experience in places like Joe Slovo actually shows that banks are more concerned with income rather than a piece of paper magically titled title deed, that they simply won't actually lend money simply by mere production of a title deed. A lot more is required in addition to the title deed. So the underlying assumption that title deeds as the silver bullet we need to unlock access to credit actually needs to be confronted. What needs to change is not giving people title. What needs to change is the policies of the banks so that they can learn how to grant or facilitate credit to people living in communal areas, in informal settlement, or people who are landless. And then there is a third problem. There are just too many of us in this country. There are 58 million of us. The Constitution requires access to land on an equitable basis. It also requires security of tenure. Nowhere does it say that this should be achieved through one model, which is the titling model. What we should be thinking about is a much more imaginative way that entrenches rights of security of tenure and that entrenches access to land on an equitable basis. The titling system ultimately forecloses and excludes the majority by far because its very basis is to cater for the minority. So by the time we have given out all of the titles, what we will discover is that there will be very little land left to give to the 40 million that will be outside of the titling model.
Let's go back then to the debate you mentioned earlier on the custodianship of land by the state. Does this completely abolish private land ownership, and will that be a game changer?
Well, you know, this needs to be fleshed out quite clearly. This debate was not part of the original discussion in 2018, because in 2018, the entire focus was on expropriation without compensation, which already presupposes that you will be targeting privately owned land for purposes of redistribution or for purposes of state ownership. The debate came through only this year, as far as I can remember, or perhaps last year, but it primarily came through on the policy platform of the EFF, and it was not part of the ANC policy platform. The ANC now seems to have adopted it, but the problem with this adoption by the ANC is that it actually lacks a clear policy position, in the sense that we don't know what version of custodianship they have in mind. Custodianship is itself a spectrum. It may be that private property ownership is totally abolished. That is a version of state custodianship. But it may also be that private property ownership is retained, but custodianship means administration. We know recently the judgment of the KwaZulu-Natal High Court, which dealt with a different form of custodianship, in other words, custodianship by traditional authorities, that it should not be conflated with ownership. That ownership still resides with the people who live on the land, although administrative functions, some administrative functions may be performed by traditional authorities. So if the version of custodianship that is on the table is not ownership, that should be made clear. And if the version of custodianship that is on the table is the abolition of private title, that too should be made clear. We should not be required to debate in the dark and to guess what the real policy position will be on custodianship. If the ultimate goal is to abolish private property, it is obviously a game changer, because that is a big decision. But I doubt if that is so. And that is why it's crucial that if you are going to change land tenure in such a significant degree, you should take South Africans seriously and put it out for debate.
I'm sure market fundamentalists, whether it is custodianship on a limited basis, would still say, no, let's let land be in the free market.
Yes, of course. And the problem with the free market ideas, I mean, I'm talking unbridled, market fundamentalism. The problem is that we have, in this country, the ANC government has been devoted to these ideas from the beginning. What happened is in 1997, the ANC had won a clause in the Constitution that required compensation to be paid on a just and equitable basis in 1996. And that was endorsed and inscribed in the architecture of Section 25. In 1997, the ANC government voluntarily passed its own policy, which was included in the white paper, in which it internalized market fundamentalism by insisting that land would be paid on the basis of what is a market-based system. But that system, by now, has clearly failed. The ANC itself is no longer just skeptical, but it has turned its back on that system. So we have been practicing a market-based system in this country for 27 years. Look where it has got us. Now, that, of course, is not to argue that the market has no role to play. But the point to be made is that unless the market is tempered by deliberate state action, there will simply be no progress in South Africa.
Now, you mentioned the Pietermaritzburg High Court judgment recently, of course, ruling that the change from the permission to occupy to now leasehold was unconstitutional, in fact deprived those people of their rights to land. The Minister of Land Reform and Rural Development, Thoko Didiza, says she is taking to heart what the courts have said and that she and others who have held the ministerial position should have done more to exercise oversight over the Ingonyama Trust and its board. Does the minister have capacity to do anything? I mean, I know already the board has got lawyers to actually appeal this particular judgment.
Let me not comment on this matter because I'm the counsel acting on behalf of the applicants. So let me talk generally about the customary system and the tenure system in the country, not specifically about the facts of the Ingonyama case, because I will have to talk about that in court soon, perhaps in an appeal court. The problem with the customary systems in this country is that the assumption of custom is based on the idea that the land belongs to the chiefs, right? And this is an old idea, largely imported, not homegrown, not part and parcel of the real custom, but largely imported from colonial rulers who were interested in concentrating power on chiefs because they perceived power as sites. They perceived the chiefs as site of exercise of political control. So the best example, perhaps the worst example, but the most iconic example is Theophilus Shepstein and the creation of a bifurcated state in Natal and the concentration then of the political authority as a mechanism of dispersing British power. Over time, that mode of administration in which the empire transmitted its own authority to chiefs who thereafter exercised it on its behalf. Some of the chiefs who resisted, by the way, were removed, new chieftaincies were created, and new chiefs, indunas, were just appointed by the government as government indunas. That system ultimately morphed into some sort of a customary law version, and it sometimes is resorted to as part and parcel of the custom, even though it's actually a perversion and a distortion of custom itself. In order to make progress on the issue of the custodianship and ownership of land in areas that are, traditional system-based, to make progress there, we, in a sense, have to append and confront the distortion first, so that land ultimately devolves downwards and power over land devolves downwards, rather than calcifying at the top between the state and the traditional authorities. So that is where I think the policy problem has been. It's the calcification of power at the top rather than its devolution to the bottom.
At the end of the day, after the amendments are done, willing buyer, willing seller, will that go away?
Willing buyer, willing seller should go. It never had a place in the first instance. It was never part and parcel of the Constitution. It is a relic. It's truly a relic of the past. It is still in the old Expropriation Act of 1975. It should be rejected. In fact, the ANC government has spoken, I think, every presidency. The last presidency was the presidency of President Zuma, who announced actually that willing seller, willing buyer should go. But they never actually took mechanisms or steps to remove willing seller, willing buyer. So if there is anything that can be achieved out of the current process, is to unequivocally reject willing buyer, willing seller, insofar as land reform is concerned. And by the way, Thabo, willing buyer, willing seller is a bit of a contradiction when you are talking about land reform or expropriation, because willing buyer, willing seller works on this fiction or this idea that you have a willing buyer and a willing seller, and an open market and a transaction that is arm's length in relation to which there is equitable competition by different people that want to buy the same asset. But in an expropriation context, you simply do not have a willing seller. The seller is forced to sell by the state. You also do not have a competing buyer. You only have one buyer. You also don't have a market because it's not as if there are competing offers. There's only one offer, it's the expropriation offer. And most of the legal authorities under the apartheid era, they identified the fiction and rejected it. And yet, the paradox is that our own government has perpetuated the fiction and then made it part and parcel of its policy. So quite apart from the fact that willing seller, willing buyer in an expropriation context is an anomaly, it should actually be rejected because it's not part of the Constitution.
Advocate Ngcukaitobi, very interesting. Appreciate your time and thank you very much for joining us tonight here on In Focus, deliberating on how government is facilitating entry into land ownership in the country and what has been slowing down the process of land reform, which is restitution, land redistribution, as well as security of tenure.